Cloud. Fantastic. Hi, Anastasia. How are you?
I'm doing good, Corey. Thank you for doing this webinar for our Pilates Bridge community about the legal essentials.
I'm very excited to be doing it. How's everything going with Pilates Bridge in the community?
It's doing good, growing, and I think a lot of people have a lot of questions. And I know like law and legal stuff is not really the most exciting topic that a lot of people want to talk about, or they want to spend, really diving deep into. However, it's just really an essential thing to be protected. So I'm super excited that you're here to share some wisdom with us.
I feel your enthusiasm, but I can't say that I agree that it's not really that fun and that people don't love it so much. I think maybe there's going to be a general feeling of being positively surprised by how much fun learning can be.
Well, that's for you to change my mind, right?
Okay, well, now there's a little bit of pressure, but I feel like I'm really going to come through on it as we do it. And I know there were some questions that came through as well that I'm going to be really happy to address. And yeah, it's a pleasure to be here. Thanks for the opportunity. And I'm practicing mat Pilates every day, so I've got my momentum going. I've got a nice little streak, and Pilates is definitely on my mind.
Awesome. So, Corey, just before we get started and dive straight into the law and legal essentials, I wanted to introduce yourself a little bit more about, obviously, your background. I know, I think we communicated, gosh, I don't know, like 5-6 years ago, or I don't even know how long ago, like our partnership has started. So you've been around, obviously, for a while. You know a lot about the fitness, yoga, Pilates community in business. So how does it all tie in? Law, fitness, movement, does it all come together?
Yeah, well, it's interesting because what the reality is that what happens is it's like any small business, right? So if you're operating a business and you are working with clients and accepting payment and transferring information and facilitating activities that have risk, you are like anyone else. The fact that it's Pilates and it's in health and wellness doesn't really change. It's not like, oh, the laws apply to all entrepreneurs, but for Pilates people it doesn't. So really where this came from was just me, I've done a Pilates teacher training and I have my practice and I'm really into it. And so for me, part of the reason why I offer legal services to Pilates professionals and have for years is because these are the people who I want to support. This is what I really care about. Like, I know for me, Pilates has changed my life in the sense of gaining flexibility, of feeling comfortable in my body, and giving me confidence in areas that I didn't have before. So it's sort of, the way it came about for me was just realizing that this is who I wanted to work with, but also at the same time realizing that the legal needs are, while some businesses are much more complex, all general businesses have legal needs. So Pilates is not an exception to that.
Yeah. And obviously, like you mentioned, all the businesses have their needs, but especially with Pilates or any type of like fitness movement, there is definitely room for, I wouldn't say error, but where you can get into some really difficult situations, right? Like if you don't have some of that legal protection in mind and things like that, you're dealing with people's bodies, we're dealing with their health, we're dealing with the properties and things like that. So there is definitely something just for people to think about and not just show up and start teaching without thinking about what are the legal implications of them teaching a person or bringing them into a studio or their home studio or whatever it is.
Exactly. And the thing is, a lot of these legal issues are invisible in the sense that like you don't think about it. Oh, now I'm a Pilates teacher, so I'm going to start offering classes out of my home or going to wherever. But if liability is a real thing and duty of care is a real thing, and it means that you're responsible. If you're facilitating an activity for another person, you're going to be responsible to make sure that they do not suffer damages by virtue of working with you. And so it is invisible. And the whole point of this conversation is to raise awareness, and being a law firm that works specifically with Pilates professionals and studios and teachers and online teachers. Really what the goal is just to create awareness and educate Pilates professionals to understand what they need in a very practical sense and the easiest way to get that.
Okay. So before we start with everything that you have to share with us, maybe you can share for people who might be watching us right now and they're thinking, well, I don't really know if I should even invest my time or anything in it. What types of situations can this legal essentials or the legal preparedness save people from, protect them from?
So while everything's going great, the need for legal documents is less important. But the moment that something goes wrong, and if everyone were to close their eyes and think about an accident that took place in their life, nobody plans accidents. We don't anticipate these things to happen. But legally, if you have your legal documents in place before something happens, in the event that something happens, you can be protected and be taken care of, and then you run a much smaller, then resolving an issue is much easier with much smaller financial penalty. So really, if the question is what can go wrong, I've done this for 6 years. I've worked with over 1,000 clients, and I've seen a lot of things go wrong. I've seen clients run studios or teachers, and they have their own Pilates students who get injured using equipment, problems with the reformer or with the Cadillac, or with other things. I have Pilates professionals who have online courses and on-demand videos, and someone gets injured on their own and their insurance didn't cover them, so then they're personally liable for all of it. I've had a lot of clients who have issues with some students that they work with, either if it's payments or cancellations or refunds or rescheduling or challenging behavior. In terms of privacy, collecting information, I've had clients who collect information. All of their online stuff has been hacked. The information's been compromised. They haven't had the right documents in place, so they've been exploited. So in some ways, it's there's so many things really that can happen. But the fix is to have your legal documents in place. And as I jump into the different types of agreements and the major issues that we see with them, the most important thing for you to be able to do is to be prepared. And I'll explain what a legal position is and why documents matter as a result, and provide some general education on these main areas.
All right, well, awesome. Obviously, you outlined a couple of those issues that we all want to avoid as teachers and business owners. So maybe you can share more about all the different legal documents that have to be set up, have to be in place to have proper protection.
Perfect. I'm happy to dive into it. And the little pretext that I want to give before explaining what the documents are is I just want to explain to everyone who's watching how the system really works and what really, if there is a problem, what's really going to happen. So again, let's say there's no problem, no accidents, no problem ever happens. Then, okay, then it's okay that you don't have documents or that you used a template or whatever it is. But it's like a seatbelt in the sense that the moment that you need it, it can totally save you. And if you don't have it properly, if it's not done properly or you're not using it properly, it can cost you your business. And unfortunately, I do have clients where it has cost them their business. Now, the thing to understand is this is how the problems actually happen. Someone gets injured or hurt or upset or disagrees or wants a refund, or there's some sort of problem. They're going to send you a letter before they hire a lawyer, usually, unless they got very, very severely injured. They're going to send you a letter and they're going to say, hey, I'm a Pilates student with you, and ABC happened, and now you're responsible to pay me $35,000 because of this thing that happened. And they believe that you're responsible and that you're liable. At that point, it's going to happen. One of two things is going to happen. One is you have customized specific agreements for you and your business, and you're going to be able to demonstrate, no, these documents actually, before we worked together, I had you sign this. This is what it says. You agreed that you wouldn't hold me responsible. And then you can respond in that way or forward it to your lawyer who can respond on your behalf. And then something that could be a really big problem and really expensive and really stressful just disappears. Conversely, if there's a problem and you have no documentation or you don't have the right documentation and there's a problem and they're going to say, hey, A, B, and C happened. You owe me $30,000. I've suffered all of these damages. I can't return to work, whatever it is that they're going to say. Now, if you don't have documents, you're not able to respond with the same strong legal position. And then you're going to be freaking out, and you're going to call me or call another lawyer, and you're going to try to understand what's happening. And you're going to realize that because you didn't set the relationship up properly from the start, you can't dismiss it so quickly and easily. And instead, there's a possibility of getting drawn into negotiations for settlement, or the possibility of actually getting sued. And now you're starting to pay a lawyer on retainer, and it's becoming very expensive, and all of your money is going away and possibly at risk. So really, but before I dive into the main issues, I just want to stress that what you're really paying for with legal documents, in addition to being protected, is knowing that if something happens, you can quickly, easily, and professionally resolve it without it taking too much time, too much money, too much effort. That's all that's required. Does that make sense?
Yeah, absolutely. Yeah, it's just like an ounce of prevention, right? Like what's that saying goes. So that's like our ounce of prevention, just that hopefully you'll never have to use it, but it's there in place to make your life easier down the road.
Yeah, perfect. So that's it. And I just explained that because as I'm going to go through these documents and talk about the specific things that are required and what makes all of them different, the important thing to know is they only work if you use them and you have them customized specifically to your business. So the first thing has to do with privacy policy in terms of service. And basically why this is really important is because online, and now everything and everyone is online, and you are always collecting personal information. So, and just so everyone knows, personal information is first name, last name, email address. Any of those would be deemed as personal information. At law, when you collect this information, you need to have a policy to say, hey, this is the information that I'm collecting from you. And just so you know that by virtue of me collecting it, if the information is compromised, this is what happens. And this is who I'm sharing it with. And these are the third parties we use and all of this stuff. And privacy policy in terms of service are straightforward because it's all about compliance. So I'm not going to bore anyone by talking about the specifics, but often it happens that clients get a general template that's not properly done for them. Some problem or issue comes up around holding personal information. Again, my first question as a lawyer is, tell me, what did the document say? Please send me a copy of the documents. Whatever we get or receive is inadequate or insufficient. My client has an inferior legal position, and then we get drawn into some form of issue. So that's really the first one for processing payments, sharing credit card information, software providers, all that sort of stuff. Client intake form. Does that make sense?
Yeah, absolutely. And since I deal with a lot of clients, maintaining their websites and doing website design for them, this is something like those privacy policies is something that I always advise that they have them drawn up and put on the website, because they don't think about it. It kind of never crosses their mind. But even the use of many marketing tools requires that those privacy policies are on the website, even just something as simple as Google Analytics or anything like that. And then obviously, they changes from country to country to a certain degree. However, there's always a requirement, like Europe is all about GDPR, and then a lot of US states, Canada, they all have some different laws. But however, it's still a requirement. And a lot of the tools that people use, not even thinking about them, they require that there's a specific part of that privacy policy that discloses that relationship, and it's there.
Exactly. So that's very prudent to direct them. And you're totally right that people don't know. And that's the whole point of this conversation is, cool, I get that you're an amazing Pilates teacher and business operator. You never think about the law, thankfully, but here's the important information that you have to consider. So that's privacy policy and terms and conditions. The second is a media release and a social media disclaimer. So this is something that we've seen probably in 2023. One of the biggest issues that we've seen come up has to do with around a media release and a social media disclaimer, and a lot of clients not really having it. So I'm going to explain each of them very quickly and explain why they're important. A media release is a document that allows you to use someone's audio, video, photo, image, likeness on your website, in your testimonials, in marketing purposes, on advertising campaigns, whatever it is. At law, the general rule is if you're using a photo of someone, you need their permission to use it. And if you profit off of the use of that image, so if you have it on your website to entice people to buy a membership, technically at law, they are entitled to some form of compensation because you are using their image to gain profit. And so that's essentially it. And we see it a lot on social media and with websites and with like advertising campaigns and Facebook campaigns. And it's just like a reminder to everyone that if you're using someone's image, you should have them sign a document that says you're allowed to use it for whatever purposes you plan on using it for. So first and foremost, that's really important. The social media disclaimer is for protection of liability for anything that you talk about or do when you're on social media. So anytime that you are saying, hey, these are some great Pilates positions to fix back pain, or this is something that's very good for touching your toes, or if you want to be more flexible, do this. Just like if you were on a one-on-one working with a client and you're telling them to do something and they follow what you tell them and they suffer damages, through social media, if you're holding yourself out to be an expert at something, you're telling someone to do it and they follow it and they suffer damages, maybe what you said was incorrect or wrong, or was your opinion about something and someone followed it. I've just seen it happen where the clients aren't protected on social media, something happens or some form of issue. And basically what you need is the social media disclaimer that says, hey, you know what, you're following us on these different platforms. You agree that you're healthy enough. You agree that you've seen a medical professional. You put all of the responsibility on who's ever watching. And it's tricky because you can't get a social media disclaimer signed. Because, you know, you open up Instagram, you do an Instagram live, you don't know who's watching, but you include it as a privacy on the bottom of your privacy and terms and conditions on your website. If you have a link tree, you include it there. And that's basically the best protection, so that if, hey, you know, linked on our website or on our link tree or whatever it is, there's a disclaimer that says by watching this that you accept responsibility for it. Does all that make sense?
Yeah, no, absolutely. Yeah, definitely. I didn't even think about like the social media part of it because it seems like everybody is on it and half of the people want to be social media influencers. It's like the top job, like between the kids and the high school and college, it's the top career that they want to pursue.
That's crazy.
I know.
Is it a university? Is there a university that offers a major in social media influencer?
I don't know. I guess somebody has to come up with it, you know.
Yeah. Wow.
But yeah, but that's definitely
that's the reality of 2023, I suppose.
I know, yeah, like very, very short attention span for people. Everybody wants to be the star. Okay, so let's keep moving on to the next one.
Yeah, let's keep rolling. So then the next document that's really important is the waiver of liability. And this is the agreement that you have with your clients and anyone who's purchasing your services or accessing your services that you're able to control. And this is the document that says, in exchange for us doing Pilates together, you agree not to hold me responsible in the event that you get damaged. And this has to be really, really specific. And it has to be specific in the way that it has to cover all the activities that you do, all the modalities, all the different ways that's offered, whether it's in person, online, on demand. It has to include all of the equipment that you include in either in your in-person services or that, people are doing at home, your clients are doing at home. But it's of all the documents, well, all of them have to be specific, but the waiver is the one that can cost you the most if it's not done properly. And then also in coming up with the agreement, it's so important that it's specific to what you do. And like I said, I've had issues with clients who offer on-demand videos. Someone gets injured on on-demand through a subscription service. The waiver doesn't say anything about unsupervised pre-recorded classes. Insurance doesn't cover them. And it's like, I've been through this. Coming back to what I said at the start, the importance is having the documents that are specific to what you do and everything around that. So that if someone's going to say, oh, well, I didn't know this, or I didn't know we'd be using the magic circle, or I didn't know that we'd be using a Bosu ball, or I didn't know we'd be using light free weights. All of it's in the waiver. They agreed to everything, and they don't hold you. They're not allowed to hold you legally responsible.
Got it.
Awesome. Let's keep rolling. And then the last agreement is either a 1099 independent contractor agreement or a W-2 employee agreement. And this is, of everything, this is the most complex question of law. The other things are pretty straightforward, like privacy policy, follow the rules. Social media disclaimer, put it in the right place, make sure it's specific to your handles. Media release has to cover all the different ways that you're going to use it. Waiver of liability, equipment, services. It's really a mistake that I unfortunately see a lot of studios make is they misclassify their workers. So everyone knows that, and just this has to do with the people who work for you. And you have a choice where you can either hire them as employees or you can hire them as contractors. Hiring them as employees is much more expensive. There's more paperwork involved. You're responsible for paying taxes and making contributions on their behalf. Whereas for independent contractors, you pay them the full amount, everything's their responsibility, and off they go. So everybody wants to have independent contractors because it's cheaper and easier to do so. Now, having said that, there are very, very serious risks to misclassification. And misclassification basically means if you call an employee a contractor, you can legally get in a lot of trouble. If there's a report from the staff themselves saying that they were misclassified, if you let them go and they feel they're entitled to unemployment insurance, this is always where it comes up. Like this is where the big issue is. And then secondly, in the event that there's an audit of your business, and it can show that for years you conducted your business by calling everyone a contractor, but really you were treating them as an employee, then you can be responsible for penalties and fines and back taxes and any other fines like that. And I have had clients who are studios who have gone out of business because of misclassifying their workers, having an enormous fine that they were unable to settle or be able to pay off, and ultimately they had to shut their doors. So it's a complex area. It's not always straightforward. And just so that it's clear also, it's always based on a jurisdictional basis. So depending on what jurisdiction you're in, it will depend whether or not even your team can be contractors. Like in the state of Florida, you can have 1099 contractors for a studio or for a business. But in California, it would be much more difficult to have 1099s, and it would be more likely that you have employees. So you just want to be really, really careful about this. And if anyone is watching and curious, like, okay, well, how do I know? How will I know who's what? It always comes down to the degree of control that you have over the services. So the first question is, what state are you in, and what are what research has been done to understand the laws on a state level? And then secondly, it would be, okay, assuming that your state permits 1099s to carry out the core service of your business, how much do you control the services? Do you tell them exactly when they have to work and where they have to work from and what time they have to be there and what they have to do? Or are you just like, cool, like, you give us your availability, let us know when you can come in, you do whatever sort of Pilates you want. You can do mat Pilates, you can do reformer Pilates, you can do anything that it is that you feel called, and our clients are going to pay you anyway. And so those are sort of the considerations when it comes to the employee contractor situation.
Right. So I'll have a question that kind of piggybacks on this. Some of the studios, they're still offering those like hybrid type of virtual in-person type of setting. And obviously they have teachers who are working for them. So like if it's an employee as opposed to an independent contractor teaching those virtual classes or things like that, is there anything different in those legal documents that have to be written up for them? Because they can be doing it from their home as opposed to from the studio or anything like that. How does all that tie in?
Yeah, so it's a really good question. And one thing to know is that when you have employees, you also, and most states require also an employee handbook. And an employee handbook is like, what are the rules? Because remember, when they're an employee, you can control the services. So you can tell them what can be done and how it's supposed to be done. When they're a contractor, you're not allowed to. So a contractor's like, come in, boom, do the thing. When they're an employee, you can say things like, okay, you always have to, if you're teaching online, you always have to wear our shirt. And we always start with roll-ups, and then we do teaser, and then we do rolling ball, or we do crisscross, or whatever it is that we do. You can tell them everything that they have to do. So if it's at home, you can't have music, you should have music. You have to wear a shirt, it starts at this time. When you have employees, you can tell them everything. Contractors, by contrast, you're not supposed to tell contractors anything. So let's say I have an online studio and I have contractors, and you were to say to me, hey, Corey, well, you have to do this and you have to do that. I could follow you, but technically now you're treating me like an employee because you're trying to control what it is that I'm doing. So also with employees, there's a lot of rules that automatically apply, because once you have an employee, now employee legislation is in play. So now, okay, what rules am I following? Is it at will employment? Have we agreed to something else? Is there going to be severance? What's the issue with that? So a lot of other questions that come into play in this area of law. Does that make sense?
Yeah, absolutely. And another question that I have, and that probably will go more for the independent contractors, because a lot of studios operate with that, is what about if one of the teachers records classes that are put on that on-demand platform? So at this point, what type of contract or legal protection is needed so there's no, there's nothing that can happen to the business owner about using that intellectual property or anything else?
This is an issue that I also have to deal with quite a bit for clients. And also remind me to talk about non-competes.
Okay.
So don't let me forget.
Okay.
But when it comes to intellectual property creation, there's a general rule. The rule is an independent contractor has ownership rights in what is created. An employee does not, so long as what they're doing is in the course of employment. So if you're an employee who works at my studio and I'm paying you an hourly rate to record a lesson that I'm going to then use to sell in my database, you're a Pilates teacher, you're teaching Pilates, the studio would own the intellectual property of the employee. With a contractor, it's not the same. So the starting point for contractors is, and I see this with creating teacher training manuals as well. It's not always just on-demand videos, but a lot of the time studios will have contractors and, hey, we want to run a teacher training program. And okay, why don't you help out? And this teacher is going to write this part, and this teacher is going to write that part. If they're independent contractors and your 1099 agreement does not have a work for hire provision, and work for hire essentially means we're paying you for this in order that we own it, like it has to explicitly state that, then at law, they're entitled to recover any profits that are made from it on a proportional level. So you want to be really, really careful. This is also why having the appropriate agreements in place is so important, right? You want to make sure that you have customized specific agreements for your situation so that you're protected. And again, I can appreciate how a lot of studio owners may not think about these things, but they're very, very real. And I can tell you there's nothing worse than being 2 years down the road on a teacher training, realizing that you never paid this person, or you never got this person to sign a document saying that you're paying them to own the materials, and they send you a demand letter saying that they're entitled to some of it.
Yeah, definitely. Yeah, that's definitely like, I've heard of some stories where unfortunately the teachers did not behave, like there's no agreement in place, and the studio owner's like, oh, we're just good friends, this is a good person. Then 2 years down the road, it's like, oh, wow, well, this person is suing me or trying to steal the clients or take away the content or anything like that. And this is not a pleasant agreement that, it's not a pleasant situation that anybody wants to be in.
Yeah.
So you mentioned that you wanted to talk about non-compete. So let's head
Thank
straight there.
Thank you for reminding me, because I otherwise would have forgotten. So non-competes is one of the most common things that will come up for me from studio owners, where they say, hey, I'm bringing this person on and I don't want them to steal my clients. I don't want them to, I'm just making a note for myself, steal my clients. Okay, so I don't want them to steal my clients. Can I get a non-compete and put it into effect? And I want to say that there's two answers to this question. First and foremost, the moment that you are hiring them as an independent contractor, it will almost be impossible to have a non-compete signed with them. The whole idea of an independent contractor is, especially in the health and wellness, and usually for the amount of hours that they're teaching, they run their own business. You're outsourcing part of your business to them. it's so counterintuitive and so restrictive on their ability to earn income that no court would want to enforce a non-compete on an independent contractor. So that's the thing to know first and foremost. And then even when it comes to employment agreements, a lot of clients are like, oh, like just put the non-compete in there. And again, this is something that's decided on a jurisdiction by jurisdiction basis. But what happens is they're almost never going to apply, because a non-compete is so restrictive on someone's ability to support themselves in their profession that if you say, okay, well, you're a yoga teacher and you're an employee and you work 10 hours a week with me and you're earning, I don't know, let's say $40 a session. So that's $400 a week. So that's $1,600 a month. There's no court that would say, yeah, that's fair. We're not going to allow that person to make any more money. You can put things in the agreement like a non-solicitation, which says, okay, you will not actively try to solicit any of our clients to come work for you. But non-competes, for the most part, will be very, very, very difficult to enforce. That being said, if they're drafted appropriately and if the role can accommodate one, like it's a full-time job, it's maybe 6 figures, like a studio manager or something like that, then it can make sense for it to apply. But generally speaking, it won't, even though everybody wants it to.
Okay, so basically kind of forget about it and don't even bother.
Yeah, and it's interesting because it's what I tell them is forget about it, but what a lot of clients want to do still is they still want it included, even though they understand that it may not be enforceable, because they want to try to scare people off. So I always just have to let them know, like, okay, you're the client, I can put in, it's not technically illegal for me to put this in an agreement, but just so that you should just be aware that if we have to try to enforce it, it would be very difficult to do so.
Okay, got it. So it's more like a scare tactic for the employees or the independent contractors, that they know it's there and they just don't want to go down the road of trying to somehow challenge that.
Exactly.
Anyway.
Exactly.
So what about, I know you mentioned about like the non-soliciting clients, and that's another situation that I've heard about. A teacher leaves and starts talking to all the clients from the specific studio to come and work with her at her house or at a different studio, or, talking bad about the studio itself or the other instructors, basically ruining reputation, things like that. Is there any type of legal protection or anything that can be done that the studio owner can protect herself and the other instructors from this?
Like I've said throughout the conversation, it's always going to depend what was agreed upon between the parties. So for example, if you have an independent contractor agreement that has a non-solicitation clause and has a non-disparagement clause, and then that person is going off and trying to steal your clients and actively sending messages to clients on Instagram. And the way that we know that it happens is that I've had this with a client before where one of the members got a message from the teacher who was leaving. And the message was like, hey, I don't know if you know, but I'm starting my own thing if you want to come join me, which is like, that is solicitation in its purest form. And in that case, we had the appropriate agreement signed and drafted. So we were able to send the person a cease and desist and say, this is what you've done wrong. Here's the signed agreement. These are the way we're suffering damages. You have to agree to ABC and whatever, and all the specifics unfold. So remember, if there's nothing written between the parties and you're just using some standard document that maybe generally says something but doesn't say it appropriately, then there's a risk that you're not protected and there's nothing that you can do. And it's the same with non-disparagement as well. Like non-disparagement, you can say, hey, you agree not to make any disparaging marks about the company in public. If you do, and we have to enforce our rights, you're going to be responsible, and for our legal fees and all that sort of stuff. And like, just to reiterate, the way the process works is there's some sort of issue that comes up. The first thing we're turning to is, what does the paperwork say? And if we have the signed agreements that are specific to you, then it's very easy for me to write an email that takes 3 minutes. Whereas if we don't have those things written down and you don't have a non-disparagement, then it's very difficult to get cooperation from someone who you're already in the middle of a fight with.
Got it. So when you mentioned a lot how important it is to have those agreements written specific way. when somebody is working with you, obviously a lot of times people don't think about those situations unless they had bad experience in the past or they heard about it. How like, do you have an interview, some kind of intake, just to figure out like what are all the elements of that legal protection that their specific business needs? How do you find all those elements for them?
Yeah, I'm happy to speak about that. And what I'm really proud of, we recently celebrated 350 5-star Google reviews. So
Awesome.
we're at 354, but I don't know who's counting. And all of them are 5 stars. And the way that we get there with our clients is that everyone's set of documents is different than everyone else, because the way everyone operates their business is different. So it's really about communication. And the way that our process works is clients will answer. Firstly, I'll usually have a consult with them, and anyone who purchases a package, we always start with a consult. So we talk for 20 minutes, they explain the goal of their business, how they operate, what their issues are, what their fears are, whatever it is. We send them a link, they answer questions. Based on that, we draft agreements. And then we go through a Google Doc back and forth, asking questions and making sure that they feel supported. And then at the end of the working together, we hop on a call to make sure that we got everything. If they're unsure about anything, all of our packages, we offer unlimited edits, revisions, and support for 3 months. So it's not like we're running away. And as clients are using the documents, we want them to feel comfortable to reach out to us to understand everything.
Okay. And let's see. I'm going through some of these questions that we received from, I think we covered a few of them.
I think that the last question that we just haven't touched on has been, how often should documents be updated and why? So there are 2 reasons and 2 reasons why documents would be updated. One is if the law changes. So for example, a couple of years ago in California, no, even better, privacy policies in California changed January 1, 2023. The law has changed. There's a new standard. We need to update the documents. And what we always do at Conscious Counsel, we send an email to all of our clients who would be affected by the change. Hey, this is the change that's happening. We got your back. This is how we support you. And, we'll give you a free tune-up for it, and we take care of it. So if in your jurisdiction something changes around the law, that's one time to change it. The second time would be if the relationship you have with your client changes. So if you're raising your prices, if you're introducing a new service, or you're now doing things online or in person or pre-recorded, or you're doing classes outside, whatever it is, law is all about using a document to capture the relationship. If the relationship changes, the contract should change as well to reflect the current relationship.
All right, makes sense. So in those cases, like the clients would contact you, like if there's a change in their relationship and their business, they will contact Conscious Counsel, and just let you guys know what's changing, and then you will provide support that they need.
Exactly. It happens often that clients, usually what's awesome is we see clients expanding and growing and doing new things. So we need to update the agreements accordingly.
Okay, got it. And I know that you have a lot of resources that we can share, that I think you can share with the community, and I will provide some of those links after the webinar as well for everybody. But I know one of those is you've prepared a special like a Pilates bundle, free Pilates bundle that people can download and just figure out like some of their legal essentials from, right?
Yeah, exactly.
And figure out what they need. And then you also had a special offer for us, and I will let you just talk a little bit about what it is and what's included in the special offer, because I feel really setting up this legal protection is so important for businesses, and it's just better just to get it done. And especially it's so much better to get all this stuff set up with a person who understands their business. It's not just some general lawyer attorney who doesn't understand anything, the runnings of the business. Not to say that that's a bad choice. However, working with somebody who speaks their language, understand all those intricacies of how the business runs is so much more powerful than just trying to explain all of that to another professional who might have no idea what yoga or Pilates Cadillac is.
Yeah, I love what I do, and it's really important for me to, I only work with a couple of industries, and I only work with industries that I myself participate in, or that I do. So I love yoga, I love Pilates, I love health coaching and learning about that, and that's who I am. So that's who I work with. And in terms of the offer, we're offering anyone who comes to us from Pilates Bridge, we're offering $400 off our package of 4 documents. So I spoke about 4 documents today, which would be the legal essentials package. If anybody has another need or wants to sub out one of the agreements for another one, we're happy to honor that as well. And the price is $3,288. With the $400 off, it's $2,888. And just to remind everyone, what that price includes is it's a one-time all-in fee, and that includes unlimited edits, revision support for a period of 3 months. So you call me whenever you want. All my day is spent on calls with clients, supporting them, working through, answering questions, making sure they feel comfortable, because ultimately I want to see Pilates professionals taken care of. Like we said at the start of this call, no one really understands these issues. And I've been doing this long enough to get that. And so this is sort of like a panacea, one side, if you operate a Pilates business, you're going to need these agreements, and we're happy to get them for you and support you in using them. And also, if there's a problem that comes up in the future, you can just shoot us a note. Like, God forbid, if you've gotten a waiver from us and someone gets injured and they send you an email, their lawyer sends you an email, you just forward it to us. And then your problems become our problems. And we're very good at taking care of our problems. So yeah, that's the opportunity for today.
Awesome. No, I think it's really great because a lot of times just a single agreement that's drafted by a law firm, well, at least for us locally over here, it can be anywhere like $2,000 just for one of those documents. So that's a way better price and a great offer for anybody who needs that.
Yeah.
Well, awesome, Corey. Thanks so much for all the time, for all your answers. We're going to have all of this conversation wrapped up, and we're going to have the transcript, all the links, everything included in the description below for anybody who wants to work. And also, Corey also offered a free consultation link. We have that one as well for if anybody's kind of like wondering, well, I'm not even sure if this is what I need, or, there's like some, who knows what questions anybody can have. So you can always hop on a call with Corey. He's a great guy. So he made legal stuff more fun for me personally. So hopefully it's going to do the same.
Anastasia, I feel like we got there, and thanks for the opportunity. And I appreciate all that you do for your community. So thanks for the chance to share the information.
Awesome. Thank you, Corey.